What is rulemaking? Rulemaking refers to the process of adopting Arizona rules as well as a document that an agency files with the Arizona Secretary of State to update the agency's rules in the Arizona Administrative Code. Rulemaking is governed by the Administrative Procedure Act, otherwise known as the APA, Council Rules, and the Secretary of State Rules and Guidelines. The primary purpose of rulemaking is to give notice to the public of the substantive and procedural requirements that an agency has established for activities falling within its statutory authority. It is the Council's responsibility to ensure that rulemakings are authorized and do not exceed the agency's statutory or constitutional authority. An agency can create substantive policy statements to explain how the agency will enforce a rule, but the substantive policy statement itself cannot be enforced on the general public. Rules are generally favored over substantive policy statements as the rulemaking process in the APA provides a formal avenue for public participation through the notice and comment process. Most agencies are subject to the APA and must follow the applicable rulemaking procedures in the statute. However, some agencies are exempt from the APA by law and do not need to seek council approval before filing final rulemakings with the Secretary of State. In addition, legislation may exempt a specific rulemaking from the requirements of the APA. There are 4 types of rulemakings available in Arizona: emergency, exempt, regular, and expedited. However, GERC only reviews regular and expedited rulemakings. A rulemaking may qualify as an expedited rulemaking if it does not increase the cost of regulatory compliance, increase a fee, or reduce procedural rights of persons regulated and does one or more of the following: amends or repeals rules made obsolete by repeal or supersession of an agency's statutory authority. Amends or repeals rules for which the statute on which the rule is authorized has been declared unconstitutional by a court with jurisdiction. There is a final judgment and no statute has been enacted to replace the unconstitutional statute. Corrects typographical errors, makes address or name changes, or clarifies language of a rule without changing its effect. Expedited rulemakings share many of the same procedures as regular rulemakings with several key differences. First, expedited rulemakings do not require the creation of an economic, consumer, and small business impact statement. Second, the public comment period for expedited rulemaking starts a little sooner than regular rulemakings. Third, after approval, expedited rulemakings become immediately effective upon filing with the Secretary of State, rather than a standard 60-day delayed effective date. The process for completing a rulemaking can vary depending on the rulemaking procedure the agency selects, the type of agency, or specific session law instructions. However, most agencies complete the following steps. When an agency decides to conduct rulemaking activity, they must contact their policy advisor to receive an exception from the rulemaking moratorium. If the request is denied, the rulemaking process does not proceed. If an agency receives approval to begin the rulemaking process, the agency files a notice of rulemaking docket opening with the Secretary of State. The agency may choose to receive informal stakeholder input from parties that may be affected by the rulemaking action. The agency will then file a notice of proposed rulemaking with the Secretary of State, which begins a formal stakeholder process wherein the agency is required to accept public comments on the rules for at least 30 days before the record closes. After gathering public comments, the agency may make technical and non-substantive changes to the rules. However, if those changes are substantial as specified in statute, the agency is required to file a notice of supplemental proposed rulemaking, and the agency is required to open the record for public comment for an additional 30 days. After the public comment period and close of record, the agency resubmits the rules to its policy advisor for final review and approval before submitting the rulemaking to the council. Within 120 days after the close of record and within 1 year from the publication of the NPR or NSPR, the agency must file a notice of final rulemaking with the council. After the rulemaking is submitted to the council, council staff reviews and analyzes the cover letter, NFR, economic, consumer, and small business impact statement, and any other supporting documents. During their review, council staff reviews the rulemaking to make sure it meets the following criteria: The Economic, Small Business, and Consumer Impact Statement contains the information required under statute. The EIS is generally accurate. The benefits of the rule outweigh the cost, and the agency selected the least burdensome and the least costly way to achieve the regulatory objective. The rule is written in a manner that is clear, concise, and understandable to the general public. The rule is not illegal, inconsistent with legislative intent, or beyond the agency's statutory authority. The agency addressed comments in the proposed rule and any supplemental proposals. The agency did not substantially change the rule from the proposed rulemaking to the final rulemaking. The agency disclosed whether or not it referred to a study in conducting the rulemaking. The rule is not more strict than applicable federal law unless there is state legal authority to exceed the requirements of federal law. If a rule requires a permit, the permitting requirement complies with statute. Once the review is complete, Council staff will prepare a memorandum and provide the rulemaking package to the Council for consideration at the Council's next scheduled study session. The Council reviews and discusses the information provided at the study session and must approve or return the NFR at the following Council meeting. Once the Council approves the rulemaking, the NFR and the EIS must be filed with the Secretary of State by the agency. The rules will become effective 60 days after the date of filing with the Secretary of State. An agency may request an immediate or later effective date by demonstrating compliance with applicable statutory requirements. For more information on rulemaking activity in the state of Arizona, view the Administrative Register. The Register is published by the Arizona Secretary of State. Weekly issues are published every Friday.